And so we're gonna jump in right now. My name is John Vance, president of Vance Wealth. Our topic for today, while business owner focus, is talking about California's shifting business landscape and are you prepared? And I think the short answer is most people are not, but we're going to help you make some progress there. Our guest speaker today is Brian Koegle, a partner at Greenspoon Marder. A little bit of background: Brian has over 22 years of employment law experience, and he heads up their labor and employment law practice at Greenspoon Marder. So thank you for joining me, Brian.
Happy to be here. Thanks for having me as always, John.
Okay, so let's just jump right in real quick from a disclosure perspective. One of the things that's really important to know: this is meant to be educational. We are going to cover tax topics, legal topics, planning topics. This is not tax advice. It's not planning advice, or it's not legal advice, excuse me. So one of the things that's really important is if you take some nuggets out of here and you want to take some action, please consult your counsel. That might be one of us. You might already be working with me or Brian or your accountant. Consult with them, because these are all planning ideas that we know can be implemented, but you want to make sure and verify that they apply to your individual situation. So let's just jump in. So we're gonna the lion's share of our conversation is going to be around employment law, but because this is business owner focused and we're starting the year, I'd be remiss to go through the importance of planning. And, Brian and I talked before this got started, and, I think we both recognize a lot of business owners don't take a proactive approach to how they handle their own business planning, their own tax planning, and unfortunately, their own HR and employment related issues. And that's when people get into trouble, right? And when you have to react to what's happening rather than being proactive, and you don't really own your own destiny. And so I think that's what hopefully you'll come out of this, is that every year we should be starting the year with this mindset of I need to focus on business planning, and we're going to walk you through some best areas, or kind of where to start and best ways to approach that. So we've all heard the term, are you working on your business or are you working in your business? Most of us know we get into the office, we're bombarded by clients, team members, emails, and we just get right into the business, and we don't spend that proper time working on the business. And so we're going to talk a little bit about how do we set up your year for success. And these are some of the best habits that we've seen over the years. And we kind of break them down into three categories. Number one is business planning. We should all be setting annual goals, if not 3-year goals, for sure annual goals. And an area that we've helped our entrepreneurs is this idea of embracing a monthly planning day. We call it a Simplify Day, really to help simplify your life. And I'm going to go through some examples of what that means. The next component of this is dealing with HR and compliance review. Are you up to date on the new rules, wage and hour related? Is your employee manual up to date, right? So we're going to go through those issues and help you really take charge of this year. And then tax planning. A lot of times especially because we're in February right now, people are thinking about last year and trying to get their books wrapped up. But we really look at this start of the year as let's get prepared for this year. Let's be proactive in what this looks like for the year that we're in. Yeah, we got to deal with the compliance from last year, but it's a mistake to wait till the end of the year to try to do planning. We really view tax planning as an ongoing thing that should be happening throughout the year. So those are like 4 key areas that we're going to run through to really help you set up some good habits as a business owner. So let's just go through a couple of these items. So what's a planning day? So I'm not going to read all these slides. The beauty of having Brian here today is we actually get to have a dialogue. But the reality is most business owners, entrepreneurs are not dedicating the time to properly plan, to properly be proactive, areas where they can make strategic decisions. And we know how hard it is to multitask and bounce between ideas. We're not that effective if we're trying to juggle too many balls at one time. So the whole idea of doing a planning day is taking 1 day per month out of the office, away from all the distractions, a lot of times away from email, away from your phone, turning things off and really focus on planning strategic areas that you need to focus on to improve your business. And one of the things that we find when you do that, because you're doing it on a monthly basis, it helps you achieve your goals at a higher rate because you're paying attention, you're reviewing them every month, and it reduces your stress load, because the things that too often you kind of push off, you're like, I'll get to that later. It really helps you refocus and say, hey, no, this is a priority. I wrote it down. This is one of my goals. And then it gives you a full day to really focus on that. And so embracing this idea of a planning day is really important. And I have a quote, we are in Los Angeles. I have a quote from John Wooden is, don't mistake activity with achievement. And I think too often we get busy And, we kind of like, it's almost like a badge of honor. I'm really busy. I'm really busy. And this whole idea of a planning day is to kind of get out of that hurried environment and just create some space, some white space for you to work on really important strategic planning areas of your life and in your business. And so I know I have a note on here that says annual tax savings. Like, how can I get annual tax savings if I do a planning day? Well, I'm going to share that as we go a little bit later in our webinar today, but it's pretty significant, some of the planning ideas that we have where you can embrace this planning day. So hopefully this makes sense. And I know, Brian, we talked before, you said, hey, I made a couple notes on this. I'm going to try to actually start putting this into my structure.
I love it. Well, and the old saying is those who fail to plan to fail. And I love the fact that you're already being so proactive and doing this on a monthly basis. I know many businesses that don't even do this on an annualized basis. So I'd love to see how this plays out for your clients and for mine.
Yeah, so one of the things, I have a kind of a sample day. Now, everybody should create their own, whatever works for them. I know I'm more of a morning person, so I try to get my day going even earlier than this. I usually will start these days in more of the 5 o'clock hour, kind of getting going because I'm fresh. But one of the things that I have found by actually embracing this planning day mentality and doing this every month is really trying to identify 3 issues. So you can see this is kind of a setup for your morning activity, which does involve some movement, exercise, eating, things that kind of nourish your brain and keep you going and healthy. But then as you get into some of the heavier work, identify 3 issues, have like 2-hour time blocks where you can actually dig into things and make an impact. And so again, everyone should structure this differently on what works for them. But if you don't have this built into the way you work currently, then try this as as a template. And then, if you're using this, report back, let us know how this is going for you, because we think that embracing this, we've gotten feedback from business owners that have embraced this, and it's really made an impact on not only their business life, but their personal life. So as we wrap up this section here, one of the things I know oftentimes it's hard to get in the right mindset to maybe change some of our habits. And if you haven't read Atomic Habits, it's a great way to kickstart, get kind of the juices flowing, get you thinking about these things. And James Clear really lays it out, gives you phenomenal examples. You can also subscribe to his, I think he does like a weekly email.
Podcast, yeah.
I know it says monthly on there, but I feel like I get a lot of communication from him. So this is a great resource for business owners that are saying, hey, I know I need to do these things, but I'm having a challenge changing my habits. This is a great resource to really kick things off. All right. So now we're going to dive into a lot of Mr. Koegle's expertise. And so I'll let you take it away here. And
absolutely. Well, and so listen, the premise of my practice is really based around one thing. I like to educate. I like to inform. What you don't know can and will hurt your business. Period. End of sentence. Especially if you're a California business, by virtue of the fact that the laws are consistently and constantly changing and being updated. If you're behind the 8 ball, you're going to find yourself in peril's way. And so my goal is to at least lay out some foundational aspects of things that are the biggest problems that we are seeing in California right now. Number one, not even close second, is violations of wage and hour law under the California Labor Code. So to start out, I just want to lay this out. I did this last year during our presentation, and I always like to start here because it really is a foundational building block. It's the minimum wage standard under California law. And listen, I understand that most of the folks who are on this call today are not down in the minimum wage range for what you're paying your employee, but it really does have an impact. The impact has a trickle-up effect. Every time the minimum wage goes up, the people who are earning $19, $20, $25 an hour, they're going to expect an increase commensurate with that bottom line minimum wage. Additionally, as I'll talk about in just a moment, it also impacts your exempt salaried employees and their compensation as well. But for 2024, the key numbers that you have to keep in mind are down in that box down at the bottom of your screen right now that basically lay out that the state of California requires a minimum wage of no less than $16 an hour, regardless of position. If you have employees who work within the city of Los Angeles, they have their own separate minimum wage. For those of you who are not in an incorporated city, so Santa Clarita, California, Burbank, Palmdale, Lancaster, Long Beach, Glendale, these are all incorporated cities within the county. They will apply either their own minimum wage or they will apply the state minimum wage. But those people who are in the unincorporated areas, down in Sylmar, the San Fernando Valley, most of the San Fernando Valley, I should say, and outskirts of Los Angeles County. If you're not in an incorporated city, you must apply the higher minimum wage standard, which for 2024, at least the first half, is $16.90 per hour. If you notice on the screen, I do have up here plus CPI. For those who don't know, that's the Consumer Price Index. That means that minimum wage will go up each and every year that our Consumer Price Index increases. I'd love to tell you that if Consumer Price Index drops and we deal with the negative CPI, that the minimum wage goes down, but I think we all know better than that. We're already projecting 2024, July 1st, we're going to see a new increase on the unincorporated Los Angeles County minimum wage. It's going to be between $17.50 and $17.60 an hour. So keep your eye on that ball, because even if you don't have people who are stationed in Los Angeles County, if they're traveling into the county for any purposes and they're doing work in their workday within unincorporated Los Angeles County, the LA County minimum wage may apply depending on your industry. So just be thoughtful on this, because it will affect that. And as I mentioned, every time the minimum wage goes up, so does the minimum salary. California ties their minimum salary to the minimum wage 2 times the state minimum wage, not the county of Los Angeles, not the city of LA or any city where you're located. It's tied to the state minimum wage. So for 2024, our minimum salary for an exempt employee is $66,560 a year. You pay even $1 less than that, I don't care if you're a CEO of the company, you are not going to qualify for the exemption standard under California law. So keep in mind that if you guys had salary exempt employees in 2023 and you have not already increased their salary as of January 1 of this year, this is the time to fix it. And then you retroactively bring them up to that higher salary for any period where you were deficient. Get it done early, because in the event of any dispute, you don't want to lose the exemption standards, because then you have to make sure all those employees are tracking their time. They're getting their meals and their rest periods. They get paid overtime as a non-exempt employee. So just be ahead of the game on this. The one other thing I want to flag on the minimum salary, for those of you who have employees outside of California, you may have remote employees who are stationed in Nevada or Delaware or anywhere else. The federal minimum wage standard currently is $35,568. This will be going up. We anticipate that it's going to go up on April 1st. The proposed rule was introduced in August of 2023 to increase the minimum annual salary to $55,000 and change per year. The Biden administration has indicated this is one of their primary concerns through the Department of Labor to get this pushed through. And right now, it looks like we are going to be at $55,000 nationwide as a minimum salary as of April 1. And then the one last thing I want to touch on this is, don't forget that even if you meet that minimum salary, the employee's duties and responsibilities still have to meet one of the very narrow exemption standards under California law.
Yeah, Brian, I have a question on that. So with the state minimum wage, I know there's the mid-year adjustment. So does that happen at the state level too, or is that only the city and the county?
That's only the city and the county. The state minimum wage always changes as of January 1. The city and county, because they work on a fiscal year, they increase theirs on July 1.
Okay, so from a practice and policy perspective, when employers are evaluating giving raises, obviously January 1's critical for them to make sure if they have exempt employees to get above this threshold, but they don't have to worry about making any adjustments, even if the city or the state makes some of those, or sorry, the city or the county make any other adjustments.
As long as they don't have employees who are regionally located within those areas that would qualify for the higher minimum wage, that's correct. Okay. But my advice, my best practice is employers should be thinking about these things at the end of December and at the end of June, making sure that they've got compliance with both standards, because remember, the benefit always goes to the presumption of the employee, not the business owner. So if the state comes back and says you should have been paying City of LA standard rather than the state standard, that is going to be your burden to prove why you weren't paying the city standard.
Okay, that makes sense.
A few other things, and I'll just briefly touch on these. It'll be in your package of information after the presentation. But if you have if you have fast food franchises, these are the McDonald's, the Jersey Mike's of the world, any place that has 60+ locations nationwide and is a common brand, The state minimum wage on this goes up April 1 to $20 per hour. That is every minimum wage worker in fast food, regardless of what service they're providing, food service, janitorial, support, etc. You will need to make sure you're paying $20 minimum wage. Understand that the legislature in California is pushing all of us to a $20 minimum wage. Their goal is to get us there by 2026. This is the first step by increasing the fast food workers. Additionally, if you're in the healthcare industry, this one is weird. I'm going to be very honest with you. There is a new minimum wage standard, and it's going to range between $18 and $24 per hour, depending on the job title and responsibilities. However, I do have late breaking news as of last Thursday afternoon. The governor has delayed this implementation of the healthcare workers minimum wage until January 1. It was officially supposed to roll out in July of this year, but because they cannot get the regulations drafted fast enough, the governor has delayed implementation of this to January 1. But those of you in healthcare, keep an eye out, because this is going to be a major change and an upset to your initial structure. You will not be able to go by the statewide standards anymore. And then finally, the wage theft claims. This is basically, from the labor commissioner's standpoint, you can no longer force an employee to arbitrate a claim if they decide to bring it forward to the labor commissioner. The state says we have a public policy that the labor commissioner's office is there to protect employees. We, employers, cannot force these things into arbitration. So just be aware that we're going to see more claims as a result of that. And then finally, the big boy, and I think everybody's probably read about this and you're sick and tired of hearing about paid sick leave. But in case you've been under a rock the last 3 months, I just want to highlight that as of January 1, every employee in the state of California, whether you have one employee or whether you have 10,000 employees, is entitled to receive paid sick leave up to a maximum annual accrual of 40 hours per year. Prior to the implementation of SB 616, we only had to provide 3 days, 24 hours. Now we have to provide 40 hours or 5 days, whichever is greater. So for those of you who have an alternative work week schedule where you're working 4 10-hour shifts, that means those employees must be allowed to accrue 50 hours annually to take as paid sick leave. You are allowed to put a cap on accrual year over year if you choose to. That cap can be set at 80 hours. So basically 2 times the maximum annual increases. Keep in mind, though, if you intend to cap your sick leave accrual, it must be in your written policies. It must be in your handbook, or if you have a standalone policy, that's fine. The same for that soft cap on the annual year-over-year rollover of 80 hours. Make sure that you've updated your employee handbooks for 2024, folks. We have several other things we'll talk about today, but this is the big one. If your policy is out of compliance, you will be subject either to audit by one of the state agencies, or an employee, a disgruntled former employee who's upset with you after you've terminated them, can turn around and sue because you don't have compliant policies under the new regulations. For those of you who are in the city of Los Angeles, or if you have employees who work remotely within the city of Los Angeles, they have to be able to accrue at a rate to be capped at 48 hours per year. So just be thoughtful on that, because they have a higher standard, a higher accrual. And as I mentioned on the last slide, remember, the tie always goes to the employee. It doesn't go in the favor of the employer in these situations. Okay. And then the last point on this particular section that I want to touch on, we talked about this last year, but so many employers are getting this wrong still. We're starting to see the first trickle of lawsuits coming in on this. If you are posting an advertisement for a vacant position, doesn't matter if we're talking Indeed or Monster or ZipRecruiter, or if you put something out on LinkedIn trying to recruit new talent into your business, you must, as a matter of course, provide the wage range that you'll be providing for that particular position. This is applicable to all employers that have 15 or more employees anywhere, whether they're California-based, whether they're national, whether they're international. If you have 15 employees firm-wide, you will have to make sure you're posting the wage range on every advertisement. You also must maintain copies of every advertisement that you have put out there advertising for your business opportunity for a period of no less than 3 years, The Koegle rule says you've got to keep it for 4 years, because there are some creative plaintiffs' attorneys out there who are calling this activity unfair business practices. So keep those records for 4 years to show that you have actually complied with the law and that you're posting not just the job description, but the wage range for that position that you have. If you don't already have this as part of your equal employment opportunity statement in your employee handbook, you need to go back and change it now. Get it up to date, get it up to speed, republish your handbook, get an acknowledgement saying that every employee has received a copy of it so they understand that you are an equal employment opportunity employer and that you do not discriminate based upon pay data or based upon sex, gender, national origin, or citizenship.
Hey, Brian, when you wrap up this page here, there is a question that came in, but go ahead and finish this and then I'll
Absolutely.
the question.
For those larger employers who are on the call today, I just want to highlight for you one more thing: the pay transparency and data reporting elements of this. If you have 100 or more employees in the state of California, you're required to provide not just your EEO-1 statement that goes to the federal government, you're now required to provide a new statement to the state of California. 2023, they delayed it several times. The report wasn't due until September of last year, but this year we've been told there will be no extensions. You must have your report into the state no later than May 8th of 2024. This is not something that you can just have turnkey done by your payroll company or your outside bookkeeper. It is a very intensive process putting this report together. You have to divide your employees by sex and gender, race and ethnicity within 10 different job categories that are defined by the state, and then separate them out by 12 different pay bands that were updated for 2024. If you need assistance with this, reach out to counsel now, because it will take you about 60 days to get this report compiled and accurate.
Wow. Oh, good times. Okay. So before we transition into this slide, one of the questions I got from Kurt Fisher: if you provide sick hours, so 40 hours at the beginning of the year, they can lose it at the end of the year?
That is correct. Yeah. So Kurt, what you're asking is a front-loading process as opposed to an accrual process. You are permitted to front-load 40 hours at the beginning of every calendar year, anniversary year. Heck, you could pick some random date that you just absolutely love during the year and say, we're front-loading your 40 hours. That then becomes a use it or lose it, because if the employee does not use it by the following January 1st, they just get refreshed with a brand new 40 hours as of that renewal date. The one thing I will caution you on this is that for 2024, it is going to be a little bit of a hiccup for a lot of folks who are front loading, because employees are going to say, well, I didn't know that I have lost my prior year's accrual. Do I not get to roll that over? And the answer is no, they do not get to roll it over. They just get the 40 hours for 2024, and you may have a little bit of an employee complaint issue. The one last thing I want to hazard employers on front loading their time, especially if we're talking about January 1st, do not be surprised or shocked that between December 25th and January 1st, people aren't feeling well. When employees know that they've got a benefit that they're going to lose, they will tend to use it for you. So if you have a production operation or a manufacturing facility, and that last week of the year is important for you to have attendance in place, you may want to think about moving it from a January 1st date.
Okay, that's great advice. All right, well, so we just finished that section, and I know we now have this next section on here, and we're kind of pausing to make sure, as we for future video, we want to make sure we actually can put this into chapters, and so I'll let you set this one up in terms of California employment law.
The second area that we see the most claims, the most number of litigation matters, the most claims that come forward in front of the California Civil Rights Division are hinged around these ideas of leaves of absence and accommodation. And we have some new changes for 2024 that employers have to be aware of and be proactive in addressing this, not just in writing a good policy, but making sure that your team members, your management team, your leaders, your supervisory staff all know about these rules, because they are your front line of defense. You want to make sure that you're doing a training for your management level employees, so they know that this is coming down the pike. The first we're going to talk about today is reproductive loss leaves. This has been a big push from the legislature for the last 2 or 3 years, and they finally passed a bill in September that basically provides that an employee who may suffer a reproductive loss, that could be a miscarriage, that could be a stillbirth, or failed adoptions, failed surrogacies, unsuccessful assisted or IVF reproduction, all of these trigger a new leave requirement under California law. This leave is protected under the California Family Rights Act, CFRA. And so therefore, this will apply to all businesses that have 5 or more employees across the board. And remember that this is presumed to be a bereavement leave. The employee has suffered a loss, and we are providing them an opportunity to take job protected time away from work in order to grieve, in order to deal with their sorrow and their pain. California has set this up such that an employee is entitled to receive 5 days of unpaid leave for every loss that they occur within a 12-month period. An employee may suffer up to 4 losses. So they could have multiple miscarriage scenarios. They could be attempting to adopt and things fall apart at the very last minute, and you must allow them to be accommodated up to 4 times a year with a maximum leave in any 12-month period, 20 days or less. This applies to any employee who's worked for you for 30 days. So at day 31, and they advise you that they've suffered a loss, you must accommodate the leave requirement. The leave must be taken within 3 months of the actual loss date. So if they suffered a stillbirth, for instance, and they decide that they don't want to take it right away, but they want to take it a few weeks down the line, you must permit that. Additionally, it does not have to be 5 consecutive days. An employee does have a legal right under this new bill to basically say, hey, I'm going to need to take the next 5 Fridays off in order to be able to go and attend therapy sessions or go see my doctor or whatever is necessary. And that is a reasonable accommodation under this new obligation. And then the last point is, while this leave is unpaid, the employer must allow the employee to utilize any accrued paid time off, vacation, or personal sick leave should they choose to use it. An employee may elect to take it as unpaid, but if they ask to be paid and to use their time, you as the employer do not have a right to deny that. Finally, I've got my reminder at the bottom. Make sure you have updated your employee handbook. This is point number 3 of the changes that must be made to your employee handbook for 24. Make sure you've got a policy in there that lays out the employee's rights so that they're educated and advised on their rights, because if you don't have a written policy, it is presumed you are not offering it to your employees, and therefore you're out of compliance with the law. Cannabis use. I talked about this briefly last year, but we got some regulations on this year, except for those of you who are in construction and building, those of you who have federal government contracts, or where if you're a supplier in the chain of a federal government contractor, when you're conducting a background investigation or a drug screening, whether that's before the employment period begins or during the employment, we should no longer be testing for cannabis in the bloodstream. Why? Because the legislature says we don't have an accurate enough test to tell whether or not someone is actually under the influence of the psychoactive elements, THC, in the bloodstream at the time of, let's say, a workplace accident or a reasonable suspicion test. What I am advising at this stage is, if you are running drug screenings through Concentra or an urgent care facility or MedCore or something along those lines, I no longer have my employers screening for cannabis containing products unless you have the employee in a safety sensitive position, are in construction or building, or have a federal government contract. It is too difficult for an employer to track. It is protected under the Fair Employment and Housing Act, as basically it presumes that you're discriminating against somebody for exercising their recreational right to consume cannabis in their own personal time. So make sure that you've updated your policies such that if you do test for cannabis, that you specifically indicate when and why and what type of test is being conducted. And then also, I want to flag that new for this year, if you have any questions on your application for employment or in your interview screening process for employees, related to personal cannabis use, you must take those out because they are now deemed unlawful under the state of California regulations.
Okay.
The other huge change that we had for 2024 is that now every single employer, save those that are ultra small, those with 10 or fewer employees, must have a separate written workplace violence prevention plan. Much of this stems from workplace violence that has arisen most recently in fights, workplace shootings that we've seen, and other claims of threats of violence in the workplace. This will require a written policy. You must train not just your management staff, but all employees on your workplace violence prevention plan. And that training and the policy must be issued no later than July 1 of this year. Now, we do not yet have a model plan drafted by CalOSHA. We are supposed to have it sometime in March or April. I've had many clients call me saying, can you help me put this together? And my statement to them is, wait, we need to see what the model plan looks like from CalOSHA, because there will be unique aspects of what CalOSHA expects to see that we cannot necessarily forecast right now and tell you with any accuracy that a plan that we put together today will be 100% compliant. So once that model plan drops, we'll all be put on notice of it. I'll be glad to send out email notification if you'd like to receive it so that you can see what that model plan looks like. We design the plan around the CalOSHA recommendations. Then we train our employees. I believe personally that this deadline of July 1 is going to be extended by about 3 to 6 months by virtue of the fact that CalOSHA is now telling us we probably won't see their model plan till April. Employers have to have time to be prepared for this. But the keys behind that, just real quickly, are going to be you have to have a plan in the event of emergency or disaster or any kind of material threat of violence. You're going to need to have a lockdown plan. You're going to need to have security. You're going to need to have something in place that if this happens in your business, you are prepared for it.
All right. Well, thanks for those updates. And we're going to move on to our next topic here.
Well, we knew this was coming, but unfortunately, I don't think any of us knew exactly how broad this was going to be. Just as a little bit of background, non-compete agreements in California have, for basically the last 15 years, been unenforceable as a matter of law. The public policy of California states that we want employees to be able to move freely, go take new jobs, go work for competitors in the workplace without restrictions or limitations. This goes back to a case back in 2008 that was called Edwards versus Arthur Anderson that basically says, we're not going to allow you to enforce those provisions of non-compete employers, but I will be candid with you. Many employers have chosen over the last 15 years to continue putting non-compete agreements in their severance agreements, in settlement plans, in performance improvement plans during the course of an employee's work for the business. But now they are full-blown illegal. They are unlawful to have a non-compete agreement in the state of California between an employer and an employee. And let me pause there for a moment. If you are selling a business, non-competes can still be used. If it is a business to an independent contractor relationship, that may still include non-compete language. We are only talking about employment relationships, employer to employee on this. But if you have at any point used non-competes in the last 2 years, you must go back and A, modify your agreements moving forward, taking out that non-compete language. And B, we actually had until yesterday, and sorry you're getting this a day late, but we had until yesterday that if you had a non-compete with one of your employees, you had to send them written notice by February 14th. Happy Valentine's Day. You're no longer on a non-compete. To anyone that we had a non-compete agreement with since January 1st, 2022. Now, don't get me wrong, guys. If you missed the deadline of February 14th, I'm still strongly encouraging you to send out those notices. So go back to your prior severance agreements. Make sure that you do not have non-compete language in there. If you do, send out a notice to the employee that indicates the non-compete provision of your severance agreement will no longer be enforceable as of January 1st, all of the remaining terms and conditions of your severance will remain true and will remain in full force and effect. Simple as that. Send that out to those individuals. Let me be perfectly clear on one other element. Employers get this confused all the time. You are still permitted to have in your separation agreements, in any written agreement with your employee, protection of your proprietary rights, confidential client lists, confidential contact information of coworkers and employees, your secret sauce, your KFC 11 herbs and spices, your recipe for Coke. All of that is still protected. You just cannot protect somebody from going to go work for a competitor in the marketplace. They cannot use the information that is proprietary or unique to your business or that is a recognized trade secret, but you can't stop them from going to work for a competitor. That's the differential, and that's what's most important for people to keep in mind. So in the future, as you're issuing severance agreements, when you're separating with an employee, you should have that confidential information and the proprietary information specifically defined so that they know what they can and cannot use if they go work for a competitor.
So, Brian, you had mentioned that, if you had done a non-compete or had that in an agreement in the last 2 years, you have to go back and change it. What if you hired an employee 10 years ago, 12 years ago, 15 years ago, and had that language? What has to happen in a situation like that?
It's only for those agreements that were entered into January 1st, 2022 and later. But you do need to understand that if that employee ever separates, when you give them a separation agreement, you need to specifically delineate that they are released from any prior non-compete agreements.
Got it. Okay. That's interesting. All right. Thank you.
Absolutely. All right.
So this is my favorite. We're not in person. I could crystal ball, maybe rub your head
Yeah. Thank you. I was going to say I got to put my Swami hat on, but yeah, I got the.
We got to have a little bit of fun with that, right? I'm catching up with you. I'm just, I'm in denial right now. So it's all good.
Absolutely. Well, and listen, obviously 2023 was a very busy year. We've only touched on some of the high points. There were a lot of other things that we skipped over today in the interest of time. Make sure you talk to your counsel about everything that needs to change. Please, please, please talk to them. But really what I want to do now is I want to focus on 2024. We are predicting that 2024 is going to be as active, if not more active, than we've seen since the COVID pandemic in 2020. Our legislature has a number of things in front of them. Our courts have a number of things in front of them that will absolutely change the landscape of employment law in California. The number one issue that we foresee is the Woolworth case that is going to be decided here probably in the next 4 months, is going to do away with time punch rounding in California altogether. A court of appeals came back and they've already struck this down in the underlying case of Woolworth. They said no more rounding is permitted. This has been taken up to the California Supreme Court. We do believe that the court is going to affirm that lower court's decision. So if you have a rounding practice, meaning your shift starts at 7 a.m., if an employee clocks in at 6:55 or if they clock in at 7:05, it rounds back to 7 o'clock so that you've got basically a balance of timing. You're giving a little bit of leniency, a couple of minutes here or there. Well, the legislature has been pushing this for years. They haven't passed anything, but the courts are now saying, listen, the technology that's available to employers today is way better than it's been in history. You have the ability to pay minute to minute and keep track of every minute that an employee works. You should be doing that because otherwise you, the employer, may be getting the benefit of free labor. For instance, if a person clocks in at 6:55 and they start working immediately, because as employers, we know they're not running to the bathroom or getting coffee or talking to friends. They're going right to work, right? They don't want the employer to gain free labor. So if you have a rounding policy in place, I am encouraging employers to change it now. Get your payroll company up ahead of this. Be ready for it because the moment that the law changes, understand that you will have to comply on the moment that that court case comes down, and we don't hold out a whole lot of hope that it's going to go the employer's way. Second, I mentioned this on the second slide, the federal minimum salary threshold is going to increase to $55,064 this year. You need to be ready for that if you have employees who are working outside of California who may have a lower salary threshold. We do expect that we're going to see the California minimum wage jump again. I mentioned that the drive to $20 an hour Governor Newsom has indicated this is a key pillar of what he wants to see. He wants to see California leading the pack on this. We do think that for 2025, we're going to see a $19 minimum wage. That will be a huge jump, won't it? I mean, this year we're at 16, possibly going up to 19 by 2025. We are advocating from business groups statewide to try to make this staged out over several years to give businesses time to adjust, to manage their pricing in order to build this up. Because if we jump $3 per hour for every minimum wage employee, it will be devastating for a lot of our smaller businesses. Our specialized industries are going to continue that drive to 20. We already have seen bills introduced for both agriculture. These are the people who are picking our produce out in the Ventura County area, film and TV, and then non-fast food restaurants. These are our larger restaurant chains where we do seated dining. All of them have bills that will be introduced this year, moving to a $20 minimum wage come 2025. PAGA, my prediction right now, is going to be a huge problem. For those who don't know what PAGA is, it's the Private Attorney General's Act. It basically is a very low bar for class action lawsuits in California, just simply put. And on our ballot in November is going to be an initiative that goes in front of the voters of California called the Fair Pay and Employer Accountability Act. This is going to really strip out a lot of the very difficult penalizing provisions of PAGA that make these cases so very hard. I was literally just in a mediation yesterday, and the mediator said, I hate these PAGA cases. Employers simply cannot win. And it's true. You cannot win on a PAGA case. It is extraordinarily difficult. So there will be that referendum. Unfortunately, there's going to be billions of dollars poured into these campaigns. And I do not believe that the voters are going to go the way of the business owner. They're going to be looking out for their best interest in protecting the employees. And then finally, a bill that has failed now 2 years in a row, and we expect it to be reintroduced next year: pregnancy leaves of absence and certain medical leaves, cancer, long-term illnesses that go beyond just a regular sick leave period, will become paid leaves of absence by the employer. Right now, they are all currently unpaid. You do not have to pay an employee while she is out on her pregnancy disability leave and then her following baby bonding leave. An employee can take up to 28 weeks in California as unpaid leave. This new bill that is being produced this year would require the employer to pay the employee while she is out on that pregnancy leave, or if they have an extended illness, pay them for the entire time that they are off work. It has not yet been assigned a bill number yet, but please know we are tracking it. We're going to do everything we can to advocate for employers to protect you. While there can be a fairness compromise in here, the burden that's going to be placed on so many employers by this additional expense may be putting many businesses out of business.
Okay. All right. Good times here in the state of California, right?
I've got the greatest job security in America, John.
All right. Well, we'll probably be reporting back next year to see what came true. And obviously, unfortunately, like you said, these things continue to move forward. And so yeah, this is not your first rodeo. I'm sure you've got a lot of these predictions right in the past.
I'm pretty good. I'm not 100%, but I'm pretty close.
Yeah. And a couple things that, oops. Hold on here, that I wanted to provide. So, when we start looking at like this idea of being proactive, and we're looking at some of the things that are coming down the pipeline from a legislative perspective, is just a reminder for me. As I know one of the things that we're big believers of is having a really strong culture, and that culture is making sure you have the right people that are working for your firm, and then also you have this culture of accountability. And so if you're looking at this saying, hey, our company's struggling with some of these issues, and because we do believe if you have a really strong employee culture, that it really helps to avoid some of this litigation. Obviously, you have to follow the rules, you have to follow the guidelines, but it really helps to lessen that. And so if you are finding that there is some dysfunction and you don't have a culture of accountability, these are two great books for your leadership team or for you as the owner to read, just to give you some perspective on some things that you can do to help improve what's happening inside your companies. Okay, So next topic we're going to jump into, and there's a lot here on this, but what I broke out is 4 top focus areas for your business in 2024. So outside of some of those real detailed employment law stuff that we just went through, updating your employee handbook being the key one with all the new legislation, let's go through these 4 top areas to focus. So listing these out, I'm gonna let Brian take one as we go through these, but review your what we call the employer best practices checklist. This is just something you should be doing every year. We're going to discuss understanding compliance responsibilities for corporations. Number 3, and we haven't spent a lot of time on this in the past, is understanding fiduciary liability with your 401k plan. And the reason why that's critical is that Department of Labor is really looking hard at 401k plans, making sure that they're built and the fees are appropriate, because they want to make sure they're protecting who? Not the employer, the employee, the end worker. And then number 4, a big believer of trying to customize your tax plan for 2024, as we are now in this new year, is really embrace a tax planning philosophy that emphasizes profit first. And we'll talk about that. I think a lot of us, we don't like to pay extra taxes, and I'm not a fan of that either. But we should always be driven by the profit motive. And too often we see businesses get in trouble because they're trying to maximize deductions and not profit. And that's just an area that I think is always good to remember, but also an area we want to help you focus on for 2024.
So I'll jump in with this. As John mentioned, every year, at least every year, let me say it that way, at least every year, you should be going through an internal checklist to make sure that what you've done is compliant with California law, that you're putting forward policies that are the strongest, best, and actually understood by your management team, and making sure that you are ahead of the curve rather than behind the 8 ball. First and foremost, performing an annual audit of all your employment practices, policies, and procedures. This includes updating your handbook. Today, I gave you 4 different places your handbook needs to be updated for 2024. You should be getting that out to your employees ASAP. I like it out by January 1st. I know that's not practical for a lot of businesses, but you should be going through it, making sure that what you have in your handbook is actually what you do in practice. Because if it's on paper and you're not following through with it, it's not worth the paper it's written on. Maintaining written job descriptions for every category of employment. This includes your exempt and your non-exempt folks. This is great for when you have to post those ads that we talked about, the pay transparency reporting, right? You need to know what you're hiring for and what role and what their responsibilities are. And these should be highly detailed. The job descriptions should also include what I call ADA compliant requirements. How much bending, stooping, lifting, sitting, standing, visual acuity, manual dexterity, or typing ability is required for every one of these practices, every one of your roles. If you do not have an ADA checklist, email me. I will send you mine. You can go down and you can create it to match with what the business does and what that particular role is going to do within your business. Auditing your exempt employees classification. Guys, I will say that 1 in every 3 lawsuits that I'm dealing with right now has something to do with a misclassification of the exemption standards. It is a huge area that is being cracked down on by many employees as they go out the door. They find an attorney, they are determined to be misclassified, and they bring a large, either a PAGA or class action lawsuit. Making sure that everybody is truly exempt is a key part of your business. What John talked about, planning, at the beginning of every month, you should be doing this on a regular basis with your employees. Updating wage claim release language. Everybody who punches in and out for your business, non-exempt employees, they should be punching in at the beginning of the day, out for lunch, back from lunch, and out at the end of the day. They should have a chance to review those punches at the end of every work week or every payroll period, whichever one you use. And then they should be signing, saying, all of the hours reflected above on this timesheet are true and accurate to the best of my recollection. I received all of my prescribed meals and rest periods, and I did not sustain any known on-the-job injuries. If you need the language, email me. I'll send it to you. Because at the bottom of the timesheet, the employee signs it, they date it. It is very, very valuable information if later on the employee comes back and says, oh, well, I worked off the clock, or, oh, I never got a lunch period. And we see a lot of those cases get struck down because we have those declarations. If you have an employee arbitration agreement, I would encourage you to update it. There were 2 new cases that came out last year that we didn't have time to talk about today, the Adolfo and the Duran case. You do need to tailor your arbitration agreements to accommodate and to incorporate those 2 new cases. So if you have arbitration agreements, send it to counsel, update it, and reissue to all of your employees. And then finally, if you haven't obtained employment practices liability insurance, talk to your broker. Talk to them quickly. Getting a policy in place is a great safety net for your business. These are not inexpensive policies in California. Why? Because the insurance companies know everything that you know. It is tough to do business in California, but it is certainly a good peace of mind for you to know that you've got that safety net in case of litigation down the road. John?
Yeah, absolutely. This is all great. Make sure, take a screenshot of this or email Brian so you can get a copy of this, because this is obviously critical for the health of your business. So a couple of things we're going to go through as well. This mainly applies to S corporations. One of the things that we find too often, especially with real small, small businesses where you're, under 25 employees, there's a lot of things you're just not doing, mainly because you're like, oh, I didn't even know I had to do that. So things like create and regularly update your bylaws, hold annual meetings for your directors and stakeholders, and keep annual minutes, even if it's just you, me, myself, and I. You still have to do that. Make sure you are doing the annual filing requirements required by the state of incorporation. Document major business decisions and meetings held. And then the last one is avoid commingling business and personal assets. You definitely don't want to pierce the corporate veil because you're just moving back and forth and the corporation becomes your own piggy bank. So be disciplined about that. There's rules that are easy to follow, but just be more conscious and more aware of that is to not violate them, because obviously a corporation is there in place to provide some legal protection for you and some liability protection. But if you're not treating it like a corporation, then it can be invalidated. So that's kind of our item number 2 here on the top 4 areas to focus on. Number 3, I have just a brief case study to go through, and this is really around your fiduciary responsibility for your 401k. So obviously we now know you are required in the state of California, if you have over 5 employees, to have a sponsored corporate retirement plan. And if you can opt out and use the Cal Savers program, but for many of you, that's not a great plan. So you opt into some level of plan. Usually it's a 401k. So a few things that we're seeing a lot of is the fact that, especially for well-established plans, that their fees are not aligned. We've been living through the last 5 years where technology is allowing all your service providers to be more efficient and to reduce fees. That includes, when you think about a traditional 401k, is you have your record keeper. And if you look on my screen here in the bottom right, Fidelity is the record keeper on this example. So this was just an example of a construction company we work with. They have about 13 million in plan assets, over 100 employees, and Fidelity was their record keeper. So you have a record keeper and they charge fees to manage the plan. You also have the underlying investments. You have an advisor that's involved, a third-party administrator. So there's a lot of components to managing a 401k. And one of the things that we're finding is that the employer, the business owner, sometimes it's the HR, depending on the size, they are not doing adequate benchmarking of their plan on a regular basis. For us, a regular basis means at least every 3 years to ensure that their plan is charging appropriate fees. And the hard thing with appropriate fees, what's appropriate, right? And so if you're not benchmarking, you don't know. And so this was a good example of a plan where we went in, we did a full benchmark, and there was 3 key areas that we identified. The business owner and their board of directors and their investment committee, they didn't want to handle a lot of the fiduciary responsibilities. So we decided, hey, let's outsource this to Fidelity using a 316 fiduciary service. So they were super pleased by that because we were able to handle a lot of the day-to-day plan operations and kind of the check the box type of compliance. It only added 0.04% to the expense ratio of the plan. We did a full investment menu overhaul to make sure they had appropriate investments for their employees. That had a dramatic cost savings from 0.41% down to 0.15%, so big savings there. And then we negotiated with Fidelity to actually, we wanted to keep the plan at Fidelity, so we negotiated to bring their fees down. And that's one of the things that we find in this space too often. If you're not asking the questions as your plan assets grow, because you have employees adding money every year, more, 75% of the time markets are going up, your plan assets are growing. So oftentimes, if you're not benchmarking, you're getting priced like you were a smaller plan. And so it's incumbent upon you as the owner, as the fiduciary, to do this. Now, for us, we act in this role. We act as a fiduciary in conjunction with our clients. But again, every time we get in this opportunity, and we kind of lick our chops around, okay, we have a great opportunity because no one's doing this work. And I say no one, maybe that's a little harsh, but not enough people are. This is an easy thing to bring in a company like ours to just do it for you. We don't charge, and we can give you a full report. And at least you might make a decision, hey, I should change from my current advisor, or at least you have now a document you can go back to them that will help to advocate to drive costs down. So in this plan example, this was an actual outcome. We can't guarantee this is going to happen every time, but basically, because of the size of the plan the plan fees were reduced from about 1% to just under 0.7. So we saved on an annual basis at current plan size over $38,000 per year. And that's spread out among some company savings as well as participant savings. But again, this is a requirement when you are managing a 401k. The Department of Labor, you're starting to see many more lawsuits pop up because of these issues. And so what we see in employment law everywhere is that anytime the employee is being harmed or deemed to be harmed, you have to then justify how you have your plan set up and make sure you have, again, appropriate investments and appropriate fees. And so I don't know if you had any questions on that, Brian, or if that all makes sense. I don't know if you're seeing that in any of the work you're doing, but this is definitely an area that we think that for this year, if you haven't focused on it, let's do it because it's going to save some real money for your company. Oh, I think you got muted. So, hey, Lauren, he's now muted. So if you can unmute him, that would be great. I will move on and keep going, but we'll get you unmuted here in a second. Tax planning philosophy. This is always an interesting one when I get into a conversation with business owners. I do think that we are wired to have this approach where we want to save taxes at all costs. And when we look at the tax landscape, the reality is you have a business that's profitable, you're going to pay tax. That's why you exist, right? So, when I look at this whole idea from a tax planning perspective, we're trying to make the right decisions and take the right deductions to be compliant and to be smart. So number one, pay yourself a market-based wage. We have been told by a lot of tax professionals, CPAs, that this is really on kind of the dirty dozen list of like business owners that are constantly paying themselves well below market wage. Usually it's to save payroll tax. If you're doing that on a consistent basis, you are opening yourself up for issues in terms of getting, you're not in compliance. And so that's number one. Number two, focus on being profitable. Don't just spend money to avoid taxes. Now, if it's helping to grow your business and it's a wise business decision, no problem. But again, the goal is to pay taxes. That means you're making money. And then number three, and I see this too often, we love to accelerate deductions by buying that car at year end or buying an extra piece of equipment and taking the Section 179 deduction. Well, make sure you understand what bracket you're in. If you're in the 24% tax bracket or lower, you might just be best to pay the taxes now. When you're in some of these higher tax brackets, then it could make sense. But just don't default into, I'm just trying to save taxes today, because our firm's tax planning philosophy is over the course of your lifetime, what decisions can we make to minimize your tax liability over your life? Rather than just in 1 year, how do we do it over your lifetime? And because we understand your long-term financial goals and objectives, we can plan for that. Now, we're never going to be perfect, but we want to have that mindset of not just focusing on one given year. We want to look at it over a course of several years, or ideally your lifetime. So it looks like we got you off mute. I don't know if you had anything to add, otherwise we can kind of jump in. So
no, I agreed with you wholeheartedly on the employment end of things, with the burden being on the employer. We have seen a number of claims that have come forward that are related to compliance issues on 401k. I will say that employers get this wrong so many times, and having an advisor like you, John, or somebody from your team able to help and guide them through these issues is an ounce of prevention is worth way, way more than the pound of cure when you come to me from a litigation standpoint.
Well, and at the end of the day, like, I think we need somewhere like 2 or 3 or 4 documents that are easy to get. And then we do all the lift. A lot of times we'll get procrastination from whoever, because people are busy, right? You can talk to the HR person like, no, I'm trying to get these reports out. I'm doing annual reviews. We don't have time. But the good news is we'll do the heavy lift. Let us go do the legwork. All we need is a couple documents, and we'll go, we tend to go shop like 3 to 4 carriers. So we take it out to market to really see, are you getting a fair deal? Then we try to negotiate with your current vendor, because ideally it's better to stay if you can, because it's less disruptive. And I think that's a lot of time people are resistant to look at it because they're like, well, no, I don't want to make a change. It's like, that's not what we're suggesting. We just want to make sure you have an appropriate fund lineup and that it's priced effectively. So, but I appreciate that feedback. And it's only going to get worse, because what's happening is plan assets have been growing and there's just a lot of neglect there, and people aren't being, even this plan that we looked at on paper, it looked like it was paying an appropriate amount of fees. But then when we got under the hood and realized we could make a pretty big change there and make a big impact. Okay, so we're going to dive in just a couple case studies and some areas where really focused around more tax planning issues. And so I know many of you have attended webinars in the past. We've discussed the Augusta rule. And so one of the things I wanted to share with you is, and I'll go through a background if you're new, what the Augusta rule is. But basically, a recent court case upholds the Augusta rule. However, it also demonstrates the importance of being in compliance, which includes documentation. And so I'm going to walk through a little bit of what this looks like. And so what is the Augusta rule? The Augusta rule is otherwise known in the tax code as Section 288G. Basically allows homeowners to legally rent out their home to their business for up to 14 days per year, resulting in a sizable tax deduction. By renting your home to your business, you can deduct the rental payments on your business tax return while avoiding the tax on your personal return under the Section 288G. So for example, if you're renting your home for 14 days at $3,000 per day, based on comparable rental options, that would create a $42,000 deduction. If you're in the 40% tax bracket, that would save you about $16,800 annually. So essentially, if done correctly, it's a tax-free distribution from the company. So that all sounds amazing, right? Like, oh, sign me up. Now, the reality is you have to make sure that there are a couple things. So these are the highlighted compliance risks. You have to have a business purpose. Why would this make sense for the company to rent your home, right? So an area we started our conversation today is about our simplified monthly planning day. So our business owners who embrace this idea of using a monthly planning day, that gives you 12 of the 14 days. And so that's one area of having a business purpose. Why am I doing this as a business owner? We think our simplified planning day is a great business usage of your time, because it allows you to get out of, this idea of working in the business and work on the business, which is a critical component of your long-term success. Item number 2, not having documentation to support the business purpose. That's why we show you, here's an agenda for a sample day. You want to take notes on what you actually covered, who might have been involved if it's not just you as the business owner. And so you want to have documentation that supports this. So this should be meeting agenda, notes. I always set up calendar invites to make sure it's clearly put on the calendar and time is blocked. The third component of this is determining fair market value rent. So this gets a little bit tricky. How do I have a comparable for my house, right? There's not a lot of people who are, renting your home on a daily basis, right? So do you use an Airbnb? Do you use a hotel comp? Do you use some filming location quote? So you just have to, you have to make sure you document fair market value rent for at least justification of how you got to the number. It cannot be made up. It can't just be pulled out of thin air just because I felt like a number. So again, this is where we really help to craft how to make sure there is a business purpose, how do we do the documentation appropriately, and then we built a tool on how to use some different ways of calculating fair market rent. But at the end of the day, once you find something that makes sense for you, you also want to be working with your tax professional to make sure that it's in compliance based on all the things that you're doing. And then, and Brian, you can feel free to jump in, but there was a court case, I am not an attorney, that basically dealt with this issue. And it was kind of interesting, right? So a part of it is like, hey, this was a win for implementing the Augusta rule, but there was also a lot of components that said, hey, kind of, I don't know if it was like shame on you, but you took too aggressive of a tactic, and you can't justify and support why you did it.
Yeah, and I am an attorney. And so I got to read through this decision, and it was what it boils down to, guys, is exactly what John just said: documentation. The plaintiff in this case, who is attempting to enforce the Augusta rule, was not the best document or record keeping business. They didn't check all the boxes that John just went down. And if you've got the documentation to back all of these things up, and you can drop it in front of the IRS if they come knocking at your door, more times than not, I can't say every time, but more times than not, you're going to be in a safe position. You just have to be really thoughtful about maintaining those documents and records in a separate file. You never get rid of them, or at least not for 10 years, to make sure that you've got it backed up in the case of an audit.
Yeah, well, and it's helpful to hear that. And a couple of the bullet points down at the bottom: unreasonable rent expense. So they kind of just made up a number. They had no real comparables, and so that obviously kind of forced the court to just throw it out and just say, okay, we think this is reasonable. So that's why we want to be proactive in the process of how we get to a number. And then the last one on here, unable to meet ordinary and necessary. That's always a little tricky one. That's like kind of the gray area. And again, that comes back to this idea of really documenting the business purpose. And so this is really a tricky one. And so you want to make sure you do it right. So if you're in listening to our webinar today, really embrace this idea of, you know what, I like this idea of a monthly planning day where I'm away from the office and I can then rent my home to my business for this, monthly planning day, then you're a great candidate for this. You're not a great candidate if you're like, oh, I want to save the money, but I don't want to do any of this stuff. That automatically disqualifies you, because everyone gets excited. Yeah, let's save the taxes, but they're not doing the day, they're not using it appropriately, and you can't just get write-offs. There has to be a business purpose. And so that's the clear message that came out. When done right, you can justify that this is a reasonable expense, but when done wrong, then you're really setting yourself up for some challenges ahead. Okay, so I went through, we had a case study actually, this was an attorney client of ours who was a partner, but full, actually not a partner, but I guess a non-equity partner. So was still getting all compensation W-2. So we had talked through and said, okay, well, is there any way you can become a non-equity partner that, maybe set up an entity like an S Corp, and they could become an ownership interest, and get paid instead of W-2, get paid directly to your corporation. And again, I'm not talking about the legal side of things. We asked those questions. Our client went to the law firm and said, hey, can you pay me in this way? They talked to legal, checked all the boxes. And so they said, okay, this client then set up an S Corp. And by having their own S Corp, they had a lot more control of how they would deal with their own payroll, how they would deal with all the retirement plan funding, and also utilizing some tax strategies. And so a few things we went through, and we had these case studies as like 2-pagers, but basically the long and short of it, by making this change from a W-2 employee to an S Corp that is getting paid directly from the firm, they were able to implement the Augusta rule, because he was a big believer of, spending that time to work on the business. He also, his spouse was handling a lot of the administrative. He's an attorney, so she was handling a lot of the administrative requirements, the bookkeeping, and a lot of things that he didn't have time to spend on. It was not a good use of his time, and she was on payroll. Children that were helping out that were in high school, they were added to payroll. And then they also got the benefit of the pass-through entity tax deduction, because in the state of California, the taxes that you pay to California are capped. The deduction at the federal level is capped at $10,000. So because his pass-through entity, because his income was so high, his pass-through entity tax payment to the state of California from the S Corp was $135,000. This saved him over $50,000 in federal taxes. And so pretty powerful. This was just a 1-year example. And so the whole point of this is not that, hey, we're going to do this for everybody. Clearly, when people come in, everyone's situation is different. But what we find too often is there's not enough purpose around making decisions, that people just kind of just say, hey, this is how things are. And they don't challenge, well, this is how things are, but how should they be? Is there a better way of doing it? And that's really what we're focused on whenever we, especially a new client coming in, is making sure we're trying to optimize it. And I would say most of the time we can add some benefit. This was obviously an extreme example, which is, why we're showcasing it here. But this is obviously a healthy example to show what is possible if you're more purposeful and thoughtful about your planning. Okay, so I always get a lot of questions around, all right, we're now in 2024. I made a lot of money last year. Taxes are going to be owed here soon in April. Like, what can I do? The short answer pretty much is nothing. Like, most of your tax planning had to happen by 12/31. Now, I would tell you there's one exception in here, and it's retirement plan funding. So retirement plan funding, you can't fund your 401k because your employee deferral had to be done through payroll prior to year end, but you are eligible to do profit sharing contributions, or you're eligible to set up a defined benefit cash balance plan. Now, I will tell you that if there are those who's sitting, listening to this video, if you have, I would say, more than 20 employees, the cost of funding these employees is prohibitive. So if you're over 20 employees, this is not a tax strategy for you. If you're smaller, especially under 10 and under 5 is even better, the fewer employees, then you get the most of the benefit of funding the retirement plan. So I'm not going to read through all this, but we basically had a client came in and kind of, we were working with the CPA. CPA was fine. It kind of was like, all right, well, this is just the reality. We can't do a whole lot. And we started looking through some of the strategies. And this is a gentleman who runs a company, had 2 employees. And so what we were able to do was basically set up a cash balance plan. He was able to fund $125,000 into this cash balance plan. And that $125,000 saved him $70,000 in federal and state tax, which is crazy because it essentially worked out to being roughly 56% 56% tax bracket. And we all know the math, right? The highest federal bracket is 37, the highest state is 13. How would you get to 56? Well, there's part of the new tax code called the QBI deduction. And in at his income level, he was ineligible for the QBI deduction, which is the qualified business income deduction. He was ineligible, but by funding to the cash balance, it moved his income below the threshold, and then he was able to qualify it. So not only did he get the benefit of the federal and the tax savings, or sorry, the federal and the state tax savings, he also got some additional benefit for QBI, which is why the tax savings was so huge. And so that was, and then now he's got 125 grand in a tax deferred account that's growing. So this was, again, just another example. And so the case studies that I'm trying to illustrate, it makes sense to just look and ask the questions, what can be done? And sometimes there's phenomenal solutions that we get really excited about that we unlock for the client. And then there's sometimes we can't. But that's where we really want to do a deep dive, because I hate when people come in and we look at their taxes for last year and said, you know what, if you just would have seen me 6 months ago, I could have made these changes, but now it's too late. So I love at the start of the year, this is the time to start, getting wired to think about things differently for 2024. So those are just some quick case studies that I want to go through, hopefully motivate you. I know when we went through Brian's stuff, there's that bit of fear component of like, okay, you got to comply with the state or else. My stuff is like, it's not fear driven, but it's also just more motivated by, hey, I want to save taxes. I want to pay what I should owe, not anymore. And so it's just taking that mindset of making sure you're doing both, right? The proactive stuff that's going to protect your business, also the proactive stuff that's going to help put more money in your pocket, maybe for your family, maybe for your community, because you want to give more to charity, whatever that might be. But these are things that you should be considering every year. And, I know, Brian, and I thank you for being, joining us for this webinar. We gave you a ton of information. So we are going to break this into small chapters and really try to share it out in the business community, because we think there's a lot of good information that people should know about. So feel free to share this with colleagues that may not be aware of this, that aren't attuned to a lot of the things we discussed today. I have had the screen up here for questions and nothing's come in yet. So what I'm going to do is just we have just a couple quick offers here. If any of you, based on this, if you're not clients of myself or Brian, on the left-hand side is Vance Wealth. If you want to have a 30-minute consultation, go ahead and you can use this QR code. You can also visit our website. And then if you want to have a consultation with Brian about some of these issues, his email is there, his phone is there as well. And for both of these, it's no cost or obligation. It's just our way of giving back to the community, but we also recognize that some of you need some help and that you might be good clients for us, and we'd love the opportunity to help on a go-forward basis. And the last one is our next webinar is going to be more focused on tax planning. It'll have 2 components: individual planning as well as business owner. And we're doing it April 16th, so the day after taxes are due for 2023. We do not have a March webinar, but we'll likely have some on-demand content that comes out that we'll send out in shorter videos. And so, as always, I really appreciate the audience, and Brian, I appreciate you. Shared a lot of great information today. So again, thank you for your time, and I enjoyed our conversation.
Always appreciate it, John. Always like getting in front of a group with you and having a chat.